This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. To find a collaborative professional near you, visit www.collaborativepracticeflorida.com. I'm Catherine Eaton with the Florida Academy of Collaborative Professionals podcast, and today's guest is Mara Bernstein. Mara is an accredited collaborative professional attorney, and she has practiced both in New York City and Florida, and she provides her clients with efficient out-of-court alternatives to expensive, prolonged, and often destructive divorce litigation. She's accredited as a collaborative divorce attorney. She is a Florida Supreme Court certified divorce mediator. Her practice focuses exclusively on all aspects of divorce, divorce consulting, pre-divorce planning, and coaching, as well as the negotiation and drafting of prenuptial and postnuptial agreements. She graduated from Cornell University and Brooklyn Law School. She's a member of the Florida Bar, the Family Law Section, the New York State Bar, South Palm Beach County Bar Association, and she is a member of the South Palm Beach County Collaborative Law Group and a member of the International Academy of Collaborative Professionals and Florida Association of Collaborative Professionals. Her office is in Boca Raton, and she practices throughout the state of Florida as well as New York. So welcome to the FACP podcast.
Good morning, Catherine.
Good morning. I was excited that you agreed to come on the podcast because we've had a couple collaborative cases together. So I know you, and we've had success with our cases. And I thought it would be interesting and good for people listening to understand how the collaborative process works and how it can be successful. And I know you're made a vow not to litigate and you're staying out of court, but can you talk a little bit about the difference between doing a collaborative case versus the other cases that you take, even though you stay out of court? What's the difference between collaborative and even though you know you're not going to court, but handling a case that isn't going to court?
Okay.
Or you're promising not to go to court.
That's a great question. You know, people have options in addition to litigating, and most often people think it's litigation or mediation, but there are a lot of things in between. There's mediation, there's pre-suit negotiations, there's cooperative. What is special and great about collaborative is that it provides clients with a container. And within that container are support systems. There's a neutral facilitator, there's a neutral financial professional, so that there is a beginning and middle and end to the process. And within the process, there are professionals working who move the process along in a very directed, very expedited and streamlined way, which doesn't happen in any other circumstance because it is actually a process. We sign a participation agreement, and we talk about what the process is and how we stay in the process.
So when a new client comes in and they're saying that they're, whether they're planning a prenup and planning exciting getting married, or things have gone sideways and they're contemplating a divorce, how do you explain to them, or the differences in the process? How do you explain the collaborative process to them versus a traditional, what everyone sees on TV, where you've been served?
Right, exactly. One of the first things that I do is I speak to prospective clients about what their goals are, what their objectives are, and what their interests are. For anyone who comes to my office and says to me, if they have children, the most important thing is that I protect my kids, or I want to stay out of court because I don't want my financial dealings in the public record, or I want to do it quickly. Those are all the benchmarks of someone who is interested in the collaborative process, because first of all, it is very client focused and it is protective of kids because we're not dueling in the courtroom. We're not having a judge decide what's in the best interest of the couple's children. Really, the couples are deciding along with professionals who have the ability to help them formulate decisions that are in the children's best interests. That's number one. Number two, confidentiality. We're not filing anything in the court record until the clients are actually getting divorced. And even in that instance, we don't have to file everything. So it's a confidential process. People, by and large, don't want other people or other colleagues or professionals looking in the court files to see what transpired during their divorce or what their financial circumstances are. Three, control over the process. By and large, when people go to litigation, they think that they're going to have this magical decision, but the truth of the matter is judges are overloaded. Their dockets are so crowded, and they know little about you, a snippet, in a couple of hours or a couple of minutes. So wouldn't you rather make your decision, and the decisions that are important to your family than have a judge who knows nothing about you? And then the other thing is that there's a definitive timeline, so that if people want an expedited process, they're not leaving it to the judicial assistant or the court's calendar or, the judge's docket. We set the meetings in advance. It's almost like a business transaction. So there's a lot of predictability to the process in terms of the time frame. So those are the things that people are looking for: control, an expedited process, confidentiality, and they don't want to spend all their money fighting with each other. And it's not that in collaborative people don't fight. You would agree, we work with the exact same people. There's still people getting divorced. They're angry, they're resentful, but I call this adult divorce. It's for people who really don't want to spend the next couple of years of their lives and all their hard-earned money fighting with each other. They want to problem solve.
In collaborative, we use a financial neutral and we use a facilitator, usually a mental health professional. And when I start to tell my clients, okay, not only do you have to hire me, but there's two other professionals that come in to helping us in this process. And then of course your spouse is going to have an attorney too. They start to gulp because there's four professionals. Can you speak to, I believe that having those, that's what makes collaborative so special, and having those neutral professionals really does move the process along and really does save money. But what is your perspective of having the neutrals involved in the collaborative process?
I don't do collaborative cases without the neutrals. The facilitator is not there for therapy purposes. The facilitator is there to move the process along, to make sure that there's communication, that there are agendas, that there are minutes. It's a very targeted, focused process. And also to help the parties if there are children with parenting issues, because there are parenting issues. So it's so customized. It's almost like concierge service. So that facilitator is moving the process along, thereby saving you time and money. In terms of the neutral facilitator, if you were doing any other in terms of the neutral financial, if you were doing any other process, you would have two fighting against each other, dueling against each other. So essentially, you're saving money because it's a more efficient process, it's a more expeditious process. And instead of fighting against each other, we're problem solvers. That's really what we do.
So now that the law has changed this past summer, there's been a lot of changes.
Yes.
And there's this presumption of 50-50 time sharing. Some of my clients are saying, well, the parenting plan is, that's nothing. It's going to be 50-50, and we don't need the facilitator to help us with that. That's there's no decisions to be made. What do you think about now that there's this presumption? What happens? The clients have a presumption coming in and they take a stance. So talk to me about the change in the law and how collaborative is working when we're talking about parenting plans and time sharing.
Sure. So I think that it takes the guesswork out of the actual time sharing, the time that each parent spends with the child. But in the state of Florida, it is required that you have a parenting plan. And included in the parenting plan are specifics. What is the time sharing going to look like? There are so many decisions to be made. And it really depends on the age of the children and where they are. Are the children teenagers? Is it going to be a week on, a week off? Are the children younger? Is it going to be Monday, Tuesday with mom, Wednesday, Thursday with dad, and then alternating weekends? And a lot of these issues are really developmental issues, in terms of where the kids are in their age, whether they have special needs. And this is something that a facilitator could help with. There are also decisions that need to be made in terms of vacation times, communication, how they're going to. I have a case right now where it's a collaborative case where the parties are having big issues as to whether or not their child should have a gab device. It's one of those telephones where it doesn't have internet, but the child could have interaction with it. The dad wants it to happen, the mom doesn't want it to happen. How do you make those decisions? So many decisions to be made aside from the actual percentage of time that each of the parents spend with the child.
So when making decisions, talk to me about how to make those decisions. What are the different styles of, so we have this checklist, are they going to have a cell phone? When do they get a driver's license? What's the holiday going to be? So there are multiple decisions to be made. So in the collaborative process, talk to me about some of the ways to make those decisions. How are they going to, when it seemed like so simple, now it's like a plethora of questions and decisions to be made.
So that's a really good question, because that's also one of the beauties of the collaborative process. A judge won't decide those things. A judge won't decide. A judge has a template and checks it off, and it's very general. In the collaborative process, you can decide those things. And what we do is interest-based negotiations. And that basically means, what are your goals? What are your objectives? What's important? And it's not a win-lose kind of situation. If we can't come to a decision, or we decide that something is really not age appropriate, we could put in the agreement that the party shall return to meet with the facilitator. And that's the beauty, because they always could have this person to help them make decisions. So they're not, people think that once they're divorced and it's going to be easy. There are decisions to be made when you have children, and to have someone who is neutral, who understands your family, who understands what your interests are and what your priorities are going forward, is really a beautiful thing. And it's a gift that collaborative keeps on giving.
Let's switch gears to the financial neutral who's helping with the financial decisions. Obviously, we just talked about parenting plan, so the financial neutral will help with the calculation of child support, but there's documents and supporting documents that need to be gathered by the financial neutral to analyze what the options are. So talk to me about what documents is the financial neutral gathering. I know you're not the financial, but you're the attorney, I'm the attorney, and we're talking to our clients. And what kind of documents do you ask your client to get ready to start finding?
Whether you're doing collaborative divorce, whether I do mediation with a forensic accountant, whether it's cooperative pre-suit, it's essentially the same document set. So in every case, we have financial affidavits, which set forth income, expenses, assets, and liabilities. Then there are mandatory disclosure that needs to be done. So it's 3 years of tax returns, it's account statements, brokerage statements, retirement statements, credit card statements. Because essentially what we want to do is we want to create a picture, and it's called an equitable distribution schedule. All that means is assets and liabilities that either are acquired premarital, that might have a marital component, and we're not going to probably get into that today, or that are marital. So we want to really create a complete picture so that the financial professional has everything in order to educate the parties, educate the attorneys, because we're not accountants, so that we could create options for distribution. And just because equitable essentially means 50-50, there are different valuations. It's almost like the parenting plan. There are so many nuances to it that we all have to be educated and get on the same page.
And as I mentioned in your bio of all the work that you do, it's not just divorce. So talk to me a little bit about your clients and how the collaborative process can be used in other issues that they have when they come to you, whether it's
Yeah.
prenups, postnups,
I love
paternities. We're
that.
talking divorce, but
Yep. So as family lawyers, and I'm sure you do the same, we do prenuptial agreements, we do postnuptial agreements all the time, and prenups are becoming much more prevalent as are postnuptial agreements. And I love collaborative for prenuptial agreements because in entering into a prenuptial agreement, this is such an important pivotal time in your life. And this is really an amazing opportunity for people to understand each other's values and priorities and sense around money and sharing and conflict resolution. So it's very, very important that people really get on the same page in terms of really being transparent with each other. And the collaborative process is the perfect place to do it because just as in divorce, even more so in prenuptial agreements, it is essential when you have a prenuptial agreement to have full and fair financial disclosure. And if there's not, there is a chance that an agreement can be set aside. So that's why it's also very, very important to have a financial professional in the case, a neutral. And also in terms of the neutral facilitator, so many issues come up with prenuptial agreements. People conflate love and money, and it's really, we need to really resolve those issues in a setting where people could enter into their marriage with respect and an understanding of each other's values and where they come from, their family backgrounds. So there's really a lot that goes into it because prenuptial agreements could be really difficult to negotiate if you have the wrong attorneys because it becomes conflict. And we don't want that to happen at that point in people's lives.
it's the beginning of January 2024. So it's it's a little bit of a divorce season right now and
Yeah.
a little bit of prenup season because there is a lot of proposals. So when doing a prenup, how much time do you say to your client, hey, if somebody calls me up and says, I'm getting married next weekend, and
Yeah.
I want a prenup, or somebody, my soon-to-be spouse put a prenup under my nose, or my parents are telling me I need one. I say, if you want one and you want me, you're not getting married next weekend. So what's the timing on the prenup? What's your opinion as to how much time it takes and how much time the parties should get it drafted and signed before the wedding day?
Catherine, I say the same. So it's really enough time. I can't say 3 weeks or a month. It's really enough time where there's full financial disclosure, a schedule of assets, liabilities, and income, supporting documentation, and negotiation back and forth in the agreement so that each party has the opportunity to review the agreement, to make any appropriate changes to the agreement, to understand the financial aspects of the other person, because people need to understand this is a living agreement. And in the event that you get divorced, it will likely be enforceable. It's very difficult to set aside a prenuptial agreement. So we need to take it very seriously. So there needs to be very robust negotiations and an understanding of the financial circumstances and the implications of the prenuptial agreement to each party.
And when you talk about the implications, talk to me about some of the issues that go into the prenup. We talked about the issues that have to be decided in the parenting plan and some of the financial issues when doing equitable distribution. So in a prenup, usually clients say, I need a prenup because I don't ever want to pay alimony again, but
Right.
there's a lot of other issues to be decided in the prenup. So talk to me about what they are and what your
Yeah,
clients are asking for.
so many other issues, and prenups are really tricky. So you really have to get someone who has experience doing prenups, and having done many prenups. So an example, someone says, okay, so I have this house, and if we get divorced, I'm going to get the house. Well, when does the other person vacate the house? What if there's marital property in the house? What if there's no divorce action pending and you die? Does the other person get the house? Who pays for the expenses of the house? Is there a mortgage on the house? What if there are repairs on the house? I'm not saying all these things to so that people are like, wow, I'm not entering into a prenup, but these are things that need to be addressed. The only things that can't be addressed are child-related items. And the reason for that is that anything that is decided with regard to children has to be in the best interest of the children, right? So if there are no children born yet, then it's speculative. We don't know what's going to be in the best interest of the children 5 years from now if we're entering into an agreement now. So it is against public policy to talk about child support or time sharing. You could state an intention, but likely it will not be enforceable. And the other
And
issues we talk about, when we talk about prenups, we talk about alimony, what happens in the event of divorce and what happens in the event of death. And very often with regard to the death provisions, because we're not estate attorneys, we work with estate attorneys to really get it right.
and in the prenups, besides the alimony, and we can't do the children's issues, talk to me a little bit about one issue that people don't think of are attorney fees. Lots of times that's whether it's how the attorney fees are going to get handled in the prenup, in the divorce, and even collaborative, because there's this, if you ended up in court, it's need and ability to pay. But,
Right.
And people get concerned. What are the fees when a client comes in? They say, how much is this going to cost me? So I know all we have is our time, but talk to me first about collaborative and attorney fees and how your clients are handling how the fees are getting paid. And then in the prenup too, how those discussions, how that's so important.
So are you asking me fees in the prenuptial process and collaborative, or fees in general?
You know what? I asked you a hybrid question, so you're good to call me on that. I just want your opinion because again, it comes back to cost. They're figuring out how they're going to divide their assets, their liabilities, whether in a prenup or in a divorce situation, and then to have attorney fees and professional fees on top of it. Those conversations need to be had. What are you talking to your clients about how to handle those issues?
So generally, and that's a great question, because it comes up all the time. We know
It
that.
comes up. So I want to know, how are you doing it? Tell
First and
me.
foremost, and you know what? I completely understand it. As if I was getting divorced, that would be my concern because, we don't really have, clients don't feel that they have that much control over the fees. And, in the collaborative process, because there is a container we kind of have a range. We know what a case may cost, which is very, very different than litigation. Divorce is not inexpensive. It's very, very time intensive, but with the collaborative process, through our experience and through the surveys we've done through the FACP and the IACP, we have ranges. So we could, I would never tell someone it's going to cost you 10,000 or 15,000, but there is kind of a range. In litigation, you can't say the range because if it goes to trial, it could be $100,000. It could be $150,000. Who knows? You might have to pay the other person's fees, right? So in the
Right.
collaborative process, generally what happens is fees are paid from marital assets. And there's an agreement at the outset, and I'm talking in generalities, of course. And at the outset, there's a participation agreement, and we agree how fees are going to be paid, and everyone is cognizant of the fees and respectful. And throughout the process, we talk about what the fees are. And we talk about it with our clients, we talk about it with our colleagues so that everyone is transparent. If you and I, when we get on a call, at the end of the call, what do?
We check our time and we make sure that we match, and we also don't socialize during those calls. We are very
Exactly. And if
business.
we
We
do
have
socialize,
agendas.
we take that out of it. Um,
Yeah.
so I would say, listen, if someone came to me, my sister, my best friend, my cousin, I would say collaborative all day long. Because not because I do it, because I do a lot of other things and collaborative is not right for everyone. But if people are willing to be transparent and come to the table and adult up and say, we're going to do this, we're going to problem solve, because it doesn't have to be that complicated. It doesn't have to be disgusting and devastating. It can be respectful.
Thank you. Thank you for being on the podcast today and answering questions and educating me. I like knowing how you're talking to your clients and how the collaborative process works in your practice.
Well, I love working with you, so it was my pleasure being here today. Thank you for asking me.